The Constitution of India. Part 6. The States. Chapter 3. The State Legislature. Legislative Procedure. Article 200. Assent to bills. When a bill has been passed by the Legislative Assembly of a state or, in the case of a state having a Legislative Council, has been passed by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the President. Provided that the governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and, when a bill is so returned, the House or Houses shall reconsider the bill accordingly, and if the bill is passed again by the House or Houses with or without amendment and presented to the governor for assent, the governor shall not withhold assent therefrom. Provided further that the governor shall not assent to, but shall reserve for the consideration of the President, any bill which in the opinion of the governor would, if it became law, so derogate from the powers of the High Court as to endanger the position which that court is by this Constitution designed to fill.
Article 200 deals with the governor's power to decide on bills passed by the state legislature. It essentially outlines the three options the governor has after a bill is passed. 1. Assent. The governor simply approves the bill and it becomes law. This is the most straightforward option. 2. Withhold assent. The governor refuses to approve the bill. This effectively blocks the bill from becoming law. However, this power is not absolute. The bill can be repassed by the legislature, and if it is passed again with or without amendments, the governor is bound to give assent. 3. Reserve for the President's consideration. The governor may send the bill to the President for approval instead of making a decision themselves. This is generally done if the governor believes the bill may affect the powers of the High Court or may be unconstitutional. The President can then either assent to the bill, withhold assent, or send it back to the legislature for reconsideration. Here are some additional key points about Article 200. Money bills. These are bills related to financial matters, such as taxes or budgets. The governor's powers are limited with respect to money bills. They can either assent or return the bill for reconsideration, but they cannot withhold assent. Governor's role. The governor is not supposed to act as a rubber stamp for the legislature. They have the power to scrutinize bills and ensure they are in line with the Constitution and do not harm the public interest. Time limitation. There is no specific time limit in Article 200 for the governor to take any of these actions. This has been a point of debate, with some arguing that it gives the governor too much power to delay bills indefinitely. Recent issues. Recently, there have been several instances where governors have been accused of using their powers under Article 200 to block bills passed by the legislature for political reasons. This has led to calls for reform, such as introducing time limits for the governor's decision or limiting their power to reserve bills for the President's consideration.